to start. Good morning and welcome to the Legal and Justice Systems Committee of the Incarceration Prevention Reduction Task Force. I would like to begin with the land acknowledgement statement. Before we begin, we acknowledge that we are gathered on the traditional and unceded territory of the Lummi, Nooksack, Samish, and Semiahmoo people who have cared for and tended this land since time immemorial. Truth and acknowledgement are critical to building mutual respect and connections across all barriers of heritage and difference. We begin this effort to acknowledge what has been buried by honoring the truth. We pay respect to their elders, past and present. Please take a moment to consider the many legacies of violence, displacement, migration, and settlement that bring us together here today. And please join us in uncovering such truths at any and all public events. I will now call the meeting to order. It is May 9th, 2023 at 11:35 a.m. I am just setting up my computer so I can see all of you. The first item on the agenda is a discussion of bail. There has been a lot of push for us to discuss bail. I'd like to remind people this isn't a discussion on reforming bail. This is a discussion to start off the conversation on how bail is established in Whatcom County and criminal courts of limited jurisdiction, as well as Superior Court and felony charges. So we'll start. I would like to let you know that one of the reasons is to protect that the bail is set is to protect victims in cases as well as the community. In courts of limited jurisdiction in Whatcom County, the most serious offenses we see that bail is set for are domestic violence matters and DUIs, which are misdemeanor cases. I'm going to give you a short synopsis or example from a probable cause statement, just to kind of give you an idea on why we sometimes are looking to protect victims on a case that was heard in Whatcom County. So you know, this individual has been charged and convicted on multiple felonies in Whatcom County and Clark County, and has served his time in Whatcom County jail for the misdemeanor cases and is now currently incarcerated in prison on his felony charges. I talked with victim 2 and learned the following. Victim 2 said she lives in Bellingham and her daughter, victim 1, just moved in with her on a date in 2021. She said her daughter had been dating A1 for almost 2 years, lived in Vancouver, Washington. A1, arrestee, had been abusing victim 1 throughout the relationship since victim 1 moved in a few days ago. A1 has been texting and calling her, and victim 1 and victim 2 said the arrestee told victim 1 if she leaves him, he's going to kill victim 1 and throw acid on victim 2. Victim 1 said while she was dating A1, he abused her almost every day. She said he would push, slap, and punch her. A few months ago, victim 1 said she barricaded herself in the room in their apartment. A1, arrestee, was able to get into the room and raped her. She'd been pepper sprayed, punched, kicked, and given a black eye. This all happened in their apartment in another county. When victim 1 moved to Bellingham, she was victimized again, and then she moved to Blaine, and in the city of Blaine, there were 12 counts, 6 counts of harassment and 6 counts of violation of a no contact order. So this is just an excerpt from one case. I am sure that you could hear many more from many others that are on these committee meetings to understand why sometimes we need to protect the victims. Sometimes it's a DUI case where we need to protect the community as well as the victim from herself or himself from others. Recently we just had a victim that was convicted of a DUI, was put on monitoring, cut the bracelet off, has been charged with hit and run, has been charged with driving without a license, without ignition interlock. These are all serious conditions where we're concerned about the safety of the community. I believe Judge Rands, who just stepped away for a second, is going to step in back in for a little bit And I did send out a copy of the release of the accused for courts of limited jurisdiction, the rule 3.2. So that was all sent to you guys, just so you have some information on how this is done. I would like to introduce Judge Jonathan Rands with Whatcom County District Court. Judge Rands holds a Juris Doctorate from the Seattle University School of Law and a Bachelor of Arts in Criminology from Simon Fraser University. He's been practicing law for over 20 years, I believe. Correct me if I'm wrong, Judge Rands. But he will be educating us on what the laws and constitutional requirements are in setting bail. And I believe with that, I'm going to let Judge Rands, also Attorney Rands, give us a little bit of feedback on how bail is set. Thank you.
You know, really, when I accepted your link, I didn't realize that you were going to make me sort of the lead on this, but I certainly understand and embrace the opportunity to educate under the canons that judicial officers are encouraged to participate in forums like this for education and also for practical reasons. So I would start out by saying, you know, bail is presumptively not to be used, but I'm also going to limit most of my comments to the area of law that I know best, and that is misdemeanor practice. I think there are some additional considerations when you up the seriousness of the charges and the allegations, but at the same time, criminal rule or CRR LJ 3.2, while it's the same as the Superior Court rule C big R LJ 3.2, I think the presumptions are still the same. Also, fresh out of judicial college, I can also tell you what the Supreme Court and the teachers and the judges that are part of the panel are concerned with respect to bail. And really, in this day and age, everybody goes back to the rule, and the presumption is that a person in a non-capital case is to be secured with the least restrictive means necessary. The rule says to comply or to make sure that they appear. And with the change in the appearance rule not too long ago, that makes bail a little bit more of an interesting question, because there was a time, it was pre-pandemic, that all appearances were mandatory and there was no appearances through attorneys. But since you can have an appearance through an attorney, I think the bail discussion is still appropriate, but it's, let's just say, in my opinion, a little bit trickier because people can appear through an attorney. Also, the presumption at bail is innocence. They are accused, while the setting of bail, if it becomes a question for the judge or if it is contemplated by the judge, we do have an obligation to make sure that not only is the rule respected, but the protection of the community is front and center as well. And that's essentially on a case-by-case basis. It's one of the reasons that the bail schedule, if you will, is frowned upon, and in some particular mindsets just considered outright unconstitutional. Simply having a across the board, this crime gets this level of bail, regardless of circumstances, takes the discretion out of it. And so really releasing an accused at any level is really a combination of judicial discretion, sometimes the wants of the state, other times the wants of the defense lawyers, if present at that hearing. But if we peel it all back, the first and foremost is presumption of innocence, and then conditions that are going to be sufficient for the case at hand. And first offense DUIs, for instance, when I say run of the mill, I mean things, the allegations might be concerning, but at the end of the day, if it's not an allegation specific to, I don't know, one party, you get a lot of unanimity in terms of the lack of bail among the judiciary, and especially if there's not a previous incident or a conviction for what started out as a DUI or even driving considerations. But let's just take the typical DUI, no history. I personally don't think a breath test factors into it on a bail analysis. Personally, I believe that the first thing that we are looking at is what's the reality of this person coming before the court voluntarily. And if we are appearing out of custody, that's a big check mark in the person's box as far as I'm concerned. They don't miss a court date. They're not being dragged here. They're showing up because there's someone to do so, or they're served with a ticket. Next question is, and of course, that's an indication as to whether they're going to follow conditions that are set. On a first offense, this has not happened before. Over is over as far as a breath test goes, in my mind, in terms of conditions of release and or bail. I don't think that it matters what kind of car the person is driving. I know that there are judicial officers out there that have had a look at the citation, and sometimes that factors into their mind. But for me, it is strictly boiling down to the rule. But there are certain circumstances where we need to consider bail, but I always think it's a last resort, especially in the misdemeanor world. And the reason there being is because any other conditions above that of the standard are likely going to cost some sort of monetary impact. And so if we can achieve the result that we're looking for, which is securing the presence of the accused and also making sure that the public is safe, or as safe as we can make them by imposing conditions that might cost some money, but are not bail, then I think everybody comes out of this with the rule intact, such as it may be a first offense, but there may be some circumstances. It might be a situation where the person is driving without a valid driver's license as a companion charge, or the person has an ignition interlock restriction, not from a prior, but just from something else. And so those are considerations as well in lieu of bail. So if we have somebody who is driving without a valid driver's license, and we are concerned that they're not going to follow the rules because they're already accused of not following a rule, rather than imposing bail, a condition of an ignition interlock might be appropriate or should be a consideration. An ignition interlock costs a person roughly about $100 a month. If you are indigent, you have the opportunity to apply for a lesser amount, or there's a fund available for pretrial conditions for that. So I guess what I'm talking about here is you have to look at the case, and the presumption is innocence. The presumption is that they will attend court and follow a court order. But sometimes there are factors, and I think, Raylene, you went through a bunch of them in a different scenario where you already have a pretty good idea of what a order is going to do. And again, it's not an automatic pivot to bail, because the problem with bail is that if bail gets set too high or a person can't reach it, now we are worried about really punishing poverty. And so in my back pocket, yeah, bail is always there, but I will tell you that I don't generally consider bail unless we have circumstances that show me that the person is not following the court orders or the court rules. A person is ordered to have good behavior, and then all of a sudden, on any given calendar, I have a new criminal charge. A new criminal charge doesn't really matter what it is, would be a violation of the conditions of good behavior. And that is something that if the court, I can consider as a judge and just say, okay, these conditions on this first case, they're probably not, well, they don't seem sufficient, because not only is the order to abide by the law, but maybe the person didn't come before the court when they were supposed to. And so that allows us to actually revisit the original case. I have been trying to make a point of this in my practice since I took the bench, in terms of we have a pending case and we have a person who comes before me on another matter that is after the conditions of release were set. I am not inclined to grant a continuance until we revisit the initial conditions of release on the first one, to either remind the person or to formally discuss an upping of the conditions of release. But that can be difficult to achieve, especially in the world right now, where we have the ability to continue cases, or defense lawyers and prosecutors have the ability to move cases along without the presence of the attorneys, sorry, without the presence of the defendants. So, I mean, at the end of the day, that Sometimes, I think it's rare, bail is necessary in non-capital, especially misdemeanor cases. But there are occasions where a person's behavior since the setting of conditions might be, or it can become appropriate. But even then, it needs to be case specific. It needs to be appropriate. I don't think that using bail to protect the public is the best use of that resource. As I said before, in a situation hypothetical presented by Raylene, there are a few things that come to mind in lieu of bail, but at the end of the day, it's always really concerning when we have a repetitive or a person accused of a crime anew, but there are sort of active threats out there. But remember, bail at the end of the day is, under the rule, is designed to make sure the person comes to court. Other conditions of release is what we look at when we want to keep the public safe. So a GPS monitor for somebody or for a arrested person or defendant in a scenario that Raylene presented, that prohibits that person from being in certain locations, or basically goes off if the person approaches the protected party's residence or things of that nature on a pretrial basis. There are many ways to be creative, and there are many ways to also not only protect defendants' rights as well as protect victims' rights or complaining witnesses' rights. The trick is to know enough about the case at the time of the arraignment to set what's appropriate and what's fair. And so the more a judicial officer has information-wise, the better off we're all going to be. And it wasn't too long ago that I was on the bench and faced with a situation where more information was necessary. And not only that, more information was helpful. And I don't mean that getting into the facts, but getting into other circumstances that will help the judicial officer make sure that the right conditions are set. But again, it can be difficult. Run-of-the-mill cases, it's bail is frowned upon, but there are situations where a person has not responded well to the conditions, perhaps has bench warranted and it's been a significant amount of time. When the person comes before, quashes the warrant, I think that's an opportunity for the judge to look hard at whether, well, the first conditions weren't sufficient, but you also have to have a conversation that's also protected in terms of what kind of bail is affordable if in fact that's what the judge is going to do. But again, I'm just going to peel it back to there's a reason that people want or are talking about bail reform, and that is because generally speaking, it is set at a level that makes it impossible for a person to postpone it or to post that bail. And then what we have is really holding people for the financial means rather than for what the rule is intended to do. And so I keep going back to the rule because that's what we're supposed to do as judges. I go back to the other portions of it. There isn't any text, if you will, in terms of balancing the rights of defendants versus the rights of complaining witnesses. That's really a judicial discretion perspective. And I think you have to have also the right mindset in terms of how much is too much for conditions. But what they hammer into us hours upon hours at judicial college is, especially at the misdemeanor level, it's a last resort, but it is sometimes something that, if necessary, you need to be careful in that you set it at a level that is meaningful. And what I mean by that is it's not meaningful to set bail beyond that which a person can do. It holds the person. But what is meaningful is a sum of money that can remind the person that, and sometimes, I don't know, I call it in the heat of the moment or before they make a decision to do something that might be a violation of conditions, would cause them to say, you know what, I might lose that amount of money, and that amount of money is meaningful to me. But again, it's a fine line, especially in today's world, especially post-pandemic, especially with all the other challenges that we face as a society. So for what it's worth, those are my comments. You have to be careful. You have to be contemplative. You have to, in my opinion, one case at a time and endeavor to keep bail there as what I would consider as a last resort. Again, this is at the misdemeanor level. I think Ms. Vanu might have some other thoughts in terms of at the felony level, just because of her knowledge and breadth of knowledge, if you will, regarding the types of crimes that come before the Superior Court. But misdemeanors are misdemeanors for a reason. It doesn't mean that they're not serious. It doesn't mean that the public doesn't need protection. It just means that the classification that they've been given deserves a separate consideration before we start holding people without essentially the ability to make bail.
Thank you, Judge Rands. Maya, do you have any comments in reference to felony bail or conditions?
I mean, the rules and considerations are essentially identical. I mean, of course, the judge is looking at, the nature of the offense that they're setting bail for, but they still have the presumption of release. There still has to be a showing of, the judge has to make a finding that there is a likelihood that the accused would not appear, that there is a likely danger that there'll be a violent crime committed. So same exact findings have to be made.
Thank you very much. Thank you, Judge Rands. Is there any questions for Judge Rands or anybody in reference to bail? I thought that was a great presentation for putting you on the spot there. Sheriff Popo. You're muted, Sheriff Popo.
That would help. There seems to be a perception on the part of the public, and we hear this in the context of the jail, that there's a lot of people hundreds of people are housed in the jail because they can't afford bail, and the bail's been unreasonably set. I don't want to put you on the spot, but is that a perspective that has any validity here in Whatcom County? I would trust our judicial officers to follow what the law requires, as Judge Rands just pointed out, but I don't know if that's a perception from other parts of the country and what they hear from watching the news, or it's something I can. And then there's ignorance involved, because I blame me for setting the bail too high all the time. I get that at least once a week. So thanks.
I'll say that I think we're lucky to have the criminal rule 3.2 in Washington that sets out these factors that have to be considered in the presumption of release. And I can't say that that's true nationally, or, different states have different standards. And so we're lucky that judges are required to examine these things when determining bail. I mean, I definitely can say I have clients who are held in jail on really low bails that they can't make because they have zero income, so the defense has the opportunity to bring bail reviews whenever we want to. The state has to have a change of conditions in order to ask for a change in bail, but it's different for the defense. So, as on my team, as we get to know our clients and their circumstances, or maybe circumstances change for them, or we develop different release strategies for them, we can bring bail to the court for review at really any time that we can note it up, and bring new circumstances or changes of circumstances to the court's attention to try to get them to reconsider bail. And we do that all the time. There's bail reviews set every week on the calendars. So thanks.
Thank you, Maya. I see questions from Stephen and Arlene.
Judge Rands, thanks for your presentation. I especially appreciated the way you seem to hew to the rule and refer back and describing your decision-making process. I'm struck at how different that is from almost the rote recitation. I've heard from other judges that bail is primarily to protect community safety, and I think your comments, not head on, but indirectly, suggested that that was not an effective tool for that. And I think that's fairly obvious for someone who makes bail. how do you align that sort of traditional rationale for bail with the reality of the rule and the reality of releasing someone simply because they can afford to post bail?
Just so I understand your question, how do I reconcile automatically imposing bail when I know somebody can afford it versus a contemplation of it when I don't think that they can? Is that your question? Am I hearing you right?
Well, no, it's that the usual rationale for bail is to protect community safety, when in fact, if you make bail, you're out. And for instance, in the factual scenario Raylene described, there were 6 violations of no contact orders. I mean, that person has a record of being unlikely to comply with court orders, and yet could be released on bail, with no benefit to the safety of the community.
As a judicial officer, or even as a lawyer, I swore to uphold the Constitution, and not only that, but the Constitution of Washington, as well as the court rules that our Supreme Court imposes. And so when it comes to conditions of release, they are, in fact, it's really unstated, but those are the things that we look at for protection of the community. While lots of people say I'm setting high bail to protect the community, I think it can be a false sense of rationale, because all setting a high bail does is keep somebody from being out amongst the community and avoids, let's just say, presumption of innocence because they are incarcerated before a decision has been made. And our rule strictly forbids using bail as pre-incarceration punishment. And so as an officer of the court and as an officer sworn to uphold the law, I don't have any qualms in terms of saying these conditions that I'm setting are designed for community safety in lieu of bail, because bail is so final, if you will. It keeps the community safe by specific deterrence, but I don't think it's specific deterrence that is fair across the board. Like I said, it can become a case-by-case scenario. I can also attest to the fact that just last week, I heard a case where a defendant was before me on a misdemeanor, but being held on a felony. And the felony bail in that case was $50. But she had sat in custody for a little bit more than a week. And Ms. Manuel's office brought an agreed motion, if you will. I mean, both the prosecutor and the defense lawyer agreed that she should be PR'd on my case and not mirror that bail, because she had sat in custody for over a week on $50. And that's why bail contemplation on its own needs to be on a case-by-case basis. And that's also why Sheriff Elfo, I think there is a presumption in the community that the sheriffs or the jail can or does set the jail. And I think that sometimes comes about because it becomes common knowledge that booking restrictions are set and or other things are set by the jail as an executive function. You have the autonomy and the authority to decide how the jail needs to be run. And I think sometimes a lot of people just miss or see a disconnect or don't understand that a person might appear in custody, a person comes before the judge and a determination is made as to whether there's bail or not. And what they miss, or the public misses, is who makes that determination. But I think in our community, I don't believe that there's a huge misunderstanding of how bail is. I think it's a fairly well-educated community. And I also think that most people are not necessarily in favor of it. But I think there's also a lot of people out there that simply, whether we're talking about bail or whether we're talking about something else, don't realize that there's an actual rule that says bail is a last resort, and we have to delineate it. I don't know that you'll ever convince that mindset of population that it's not a good thing to just lock a person up and throw them away a key versus giving them their day in court or having them stay in jail.
Thank you, Judge Rand. Arlene?
Yes, you mentioned several times that bail is used to remind people to show up. And that made me wonder if messages or a reminder calls are being made to people.
I believe people, well, from district court, they receive a mail summons after a court date is set. In district court, we send them 2 sets of dates. One is for an omnibus hearing and one is for a jury trial date. After the hearing where those dates are set, and every time that hearing is held and or continued, if they are not present, their attorney is responsible for giving them the new date, and that is the certification that an attorney will sign off on, that they are in touch with the person and have their permission to move it, and essentially will get them the new date. There's also a mailing that goes out, and there's also as far as probation appointments and even pretrial supervision appointments, I do know that there's reminders as well. But you have to overlay that with a large part of the population who can't afford bail are generally that same population that may not have a mailing address, that may not have the ability to buy or even have a burner cell phone that or prepaid. And so what we have is sometimes you have contact problems, which is why it's also, I think, an abundance of caution on a case-by-case basis. When a person doesn't show up, we do have another court date that's set, and it's my practice to always give another chance or another opportunity to figure out if they can appear at another court appearance before we even issue a warrant that then is attached to the ability to remove that warrant with the payment of some sort of bail or some sort of quashing fee. So the short answer is yes, there are reminders. And in I'd say in the old days, when I first started practicing, every court appearance was mandatory, and people would actually sign a carbon copy in most courts for the next court date that they would receive. And that was your notice. And so the court could look back at the last hearing, see when the date was set, see that the person signed for it. And that's when I think some judges would say, well, I've got a failure to appear, I've got solid notice. And so I'm either going to issue a warrant or I'm going to issue, or I'm going to find that if you don't show up at the next one, that's a failure to appear, and use it to justify bail. But things have changed so much now, especially with the ability of some change in some rules. But at the same time, we always, as a judicial officer, and I think even as a society, we always need to remember that one of the reasons we don't want to impose bail is because we don't want to punish poverty. And even if we do have means of notifying people, not everybody in that socioeconomic status before the court is going to be able to take advantage of or receive those notices. We have lots of general mailing post office addresses. We also have lots of numbers through probation that constantly change. But there's also the rule at arraignment, and even throughout, I try to remind people, make sure that the court is aware of your current mailing address, or that your attorney or probation is aware of your current phone number, because sometimes we can forget up here that there is a population that doesn't have the resources that we don't even consider a resource anymore. They're just a fact of life, but they are luxuries in a lot of times, and they're not necessarily, but we've come to treat them as sort of a, what's the word I'm looking for, an essential service, but a lot of people don't have those things that are essential services that we look at. So case by case is always the best, in my opinion.
What do you think about the movement to remove bail?
I don't know, as an officer of the court and being bound by judicial canons, I can answer that question other than I have to follow the law, and I promote instances that allow me to follow the law. So sorry, I can't be more direct, but when I participate in these kinds of forums, the canons are pretty clear in terms of what my personal opinion can or should be versus what I'm sworn to do.
Thank you.
I just want to mention, Arlene, too, that I believe it's district court probation sends out text reminders for court dates. So those go out regularly to people. Our attorneys call clients before the court date to have some communication with them and / remind them, assuming that they can reach them. But all clients, at least in Superior Court, will have signed a document that has a mandatory court date on it. It might have an intervening court date where appearance is not required, but they will have a document that has a mandatory court date on it as well.
And Arlene, from the municipal courts, that I'm aware of, we have them sign a promise to appear. We make sure that we get their contact information. We're getting more diligent about asking people for email addresses so that we have that information, as well as to be able to provide that to defense counsel, because as Judge Rance mentioned, sometimes the individuals that we're working with, they don't always have a address that they can stay on. When it's a domestic violence case, they may just have gotten a no contact order and they don't know where they're going to go. But a lot of times they still have access to email somehow, not always. So we try to get some type of contact information so we know how to send it to the individual while we're waiting for them to get a permanent address. So the district court for probation for all the small cities, with the exception of Ferndale, does send text messages for probation court appointments as well for the courts. And we're working with AOC on hopefully getting something in the new system that's going to allow us to do email reminders, but that's a ways out yet. But we're working towards getting that, and the small courts are getting creative on trying to make sure that people know what their court dates are, as well as making sure that information is updated in the court system for other courts on their email contact and updated phone numbers and addresses. I saw Kristen's hand up, but I want to allow Jonathan to respond back real quick, and then we'll go to you, Kristen. Thank you.
There is a movement among the court rules with respect to showing up. In fact, it's not even a movement. Access to justice is really everything that we are about and everything you learn about at judicial college, and it's the big push right now. So that's one reason that the rule changed, but also what I wanted to let you know is that the rules have changed in terms of what a physical appearance is, or what an appearance is. And with the advent of Zoom and the pandemic, we've learned a few things. And if you give the person an opportunity to show up via Zoom versus not having to take 5 buses or miss work or things of that nature, again, the question of hitting somebody with bail because they don't show up, it becomes less and less of a concern when we have more and more mechanisms to allow people to make an appearance, especially at a time where I'm going to say it's not necessarily a critical stage. We always want to see people in person at critical stages, such as when conditions are being released, or when a trial is being conducted, or when a plea and sentencing. Those are all good examples of conditions or critical stages. Other matters where it's just a matter of getting a date, other means of getting people to court also keeps certain people safe. What I mean by that is, if you have a complaining witness or a victim from a previous matter and they are involved in the new matter, they can participate in the court proceedings by Zoom and watch and be safe. Or if we know that they are going to be in the courtroom at the same time, that's an accommodation that we can make for them, where we can have the defendant appear via Zoom. And remember that the point of an appearance is to make sure that we have a person's attention and they're paying attention to the dates and the rules that are set by. And so with a little bit more technology being used these days, and our court rules actually embracing it and authorizing virtual appearances or platforms. And I'll tell you right now, Judge Anderson and I and Commissioner Parise were working on some local rules that will entrench, if you will, the ability and what a physical appearance is, and mirrors the state rules at a local level. Again, this is for access to justice. This is to make sure that we don't have to issue warrants if a person is unable to come to court, and also it allows a person or a victim to participate and yet remain safe.
Thank you. Kristen?
I was just wondering, maybe if, maybe this question's more for Maya. But how big of a factor would a court navigation program or something like that, where there was support for compliance, you know, between the time bail or conditions of release were set and the disposition of the case? I know that the Public Defender's Office did present to the Stakeholder Advisory Committee some sort of a program that they had heard about. And it sounded like that might help streamline the whole pretrial process if we had a similar program here. And I just thought that if we were talking about bail and conditions of release, if you think that that would enhance our criminal system here in Washington County.
Thanks, Kristen. I think you're referring, we talked about Partners for Justice, which is a program that's embedded and embeds social workers in public defender offices to assist our clients. And that is primarily pre-trial. So yes, you know, we currently have 2 behavioral health specialists, but they are really tapped out just doing mitigation report work. They don't have the capacity to do like caseworker type work, or which is what that program envisions. I mean, I know that we have our pretrial services department, and you know, there's a small work group that's a subgroup of the Incarceration Prevention Reduction Task Force that needs to analyze, you know, whether the risk assessment, the tool that's being used is appropriate or not. And we're really kind of focusing on that right now. And they only have 1 employee in that program. And, you know, when judges order pretrial supervision in Superior Court, it really just mandates regular check-ins, whether by phone or in person, with the pretrial services to really just maintain contact and assure that phone numbers and addresses are up to date. So I mean, I like, we could definitely be serving people pre-trial and getting them linked to services more and trying to assure stability in their lives and in a more proactive fashion through my office if we have the resources to do that. We certainly try to refer people to the LEAD program or GRACE if they meet the admission criteria there. And you know, those case workers are fabulous, but they don't share they're not under the umbrella of confidentiality, and so that can create sort of divisions. And you know, we don't share strategy with people outside of our office, and so it's not. I think there probably are better ways to serve our population than we're doing right now.
Okay. And it sounds like too, it would help prevent a lot of failure to appears, as well as promote some early compliance and thus streamline the process. Maybe if there's
Yeah, I mean, our behavioral health specialist goes out to homeless camp and bring people into court on a regular, you know, as much as they can. And like we've linked up with the Lighthouse. They've got an employee there who has made available a vehicle, and she really is kind of available on call to us. If we've got someone, we can be like, we got to get this person in. Will you drive us out there? We can put them in your van and get them in if we can. And so, but like I said, there's only 2 behavioral health specialists, and they're really, well, we ask them to do it because it's just like a fire and it has to happen and it's an emergency, and they're constantly setting aside other things they're supposed to be doing to do that. Yes.
Okay. Well, it sounds like
some people need that level of help.
Thank you.
Well, a lot of the population that we're talking about is having co-occurring disorders, which in terms of expecting usual rational behavior, when the person is unstable and not sober, is like two different realities entirely. So this is one of those, another one of the behavioral health gaps that has come up a number of times in our conversations, where we need to aim some more staffing.
And just on a side note, because we have in the past discussed reentry and navigation assistant. A lot of times it's more focused on people with mental health issues. But we need to have it for both reentry when it's a pretrial position to when it's a post-conviction, when they're reentering from prison or when they're reentering from jail. And I think that's a bigger topic that we need to address at another meeting. But we have had that on our agendas before in the past, and we're happy to put it on again. I think it's also something that we use the behavioral health when we go into our joint meetings, because a lot of times it is not just a legal injustice, but it's a joint issue with the behavioral health, as Arlene was pointing out, that a lot of them have co-occurring disorders. Is there any other questions for Judge Rands, or any thoughts on where you guys would like to go with this bail topic in the future? Thank you. Don't see any hands. I don't hear anybody else talking. So thank you again, Judge Rands, for joining us today. I really appreciate your candidness and what you could speak about, and respect that you're respecting the canons and making sure you're not violating them while you're on the bench. Appreciate that. And then I believe
They are important.
they are important, and I respect that. So I really appreciate it. In the rest of your packets, as I'm trying to find mine, because I set it aside as we were talking about this, we have our end of the month report. Jill, could you actually put that up for me?
The annual report, is that what you're looking for?
Yeah, the packet that we
Yeah, let
yes.
me give
Thank
me
you.
a moment to do that. There you go. Do you see the packets?
I do. So if we could just kind of scroll down towards some of the questions that you had highlighted. I don't know if any of you have had a chance to look at the annual report outline. But there's some areas that are highlighted that if we have any input on any of these, if you just want to scroll slowly, I would appreciate it.
Yeah, sure. Let me just say that the version that I'm showing here that's in your packet is not exactly the most recent update. I've had some feedback from some of our members and have been able to update this version a little bit. So I will email to you all the most current version of the summary for both this committee and the joint committee meetings that you have. And I'll be reaching out to those folks who I'm hoping to get information from or updates from. A lot of these are just updates from about presentations that occurred last fall. And so I was hoping to include more current data in this annual report. So really this is the content of the annual report in a very rough draft, first draft. It has not been reviewed for any kind of or proofed for any spelling, grammar, that kind of stuff. So, but now's a good time to put eyes on it. If you see anything that's egregiously wrong or missing, please reach out to me and let me know. And I'm happy to make corrections. Now is a good time to make those big corrections rather than in a month when we're finalizing it for approval. Yeah, that's about it.
Thank you, Jill. Is there any comments right now in reference to the annual report? Don't see any hands, so I'm going to go to other business. I believe the next Legal and Justice Subcommittee is going to be focusing on juvenile justice. I expect Susan, and I can't remember her name right now, but she is in charge of the CQ unit at St. Joe's Hospital. And she will be speaking on the gaps that we have currently at the hospital in reference to juveniles. We're gonna talk to Dave Reynolds on some of the requirements in the Criminal Justice Center. Also, anybody that wants to speak on lack of treatment or the need for treatment on juveniles in the future. There's other topics that you would like to see in the future for the Legal and Justice Committee, please let myself, Arlene, or Jill know. We'd be happy to get those on the next agendas. Is there any other comments currently in reference to other business? All right, do we have anybody in the public, Jill?
Yes, we do have a number of attendees remotely today. I have one hand raised. Let me give you permissions to speak. Rupert Ayton, go ahead and speak to the committee.
Oh, thank you. First, I wanted to thank everybody for a really informative session and make a couple of comments and ask a question. Sheriff Elfo mentioned sort of the misinformation that's out there, and I think that's really true. I think we're talking about a really complicated system, and there's a sort of a real lack of transparency out there, and I think folks tend to grab hold of something and run with it without necessarily understanding it. And me as a Bellingham homeowner who's really interested in this question and concerned about the jail and everything else, I feel like it's my responsibility to try and educate myself and figure out who knows the facts, find the facts, and be able to tell my friends about where to find those facts so that everybody can inform themselves as much as possible, as difficult as that may be. I have a question. I am a member of the Bellingham Unitarian Fellowship, and we have a group of us who get together and talk about these issues on a regular basis, and we have guest speakers come and talk to us, and we love to have guest speakers from this field come and talk to us. One of the guests that's going to come and talk to us next week is Friendship Diversion Services, and what I'm really curious about, and perhaps this can't be answered by you guys, is why their services are used at the district court level, but not the superior court level. And maybe the simple answer is because those services aren't applicable. But if someone has an answer for that, I would love to know.
Judge Rance?
I can't speak if I think they're available in Superior Court, are they not? Ms. Vanu, but they started out being first used in Bellingham Municipal Court, and as a practitioner, I became very familiar with Friendship Diversion Services, and I believe our predecessors to Judge Anderson and myself, for whatever reason, did not feel like it was an appropriate program for district court. Again, I was practicing at the time and wasn't in chambers to know the rationale for that. But I can tell you that Judge Anderson and I have begun to use them routinely. I use them as often as I can when a person either has a long wait for a jail alternative program that may not be ready to receive them yet. Also, many people who are not residents of the county don't always qualify for jail alternatives. But I can tell you that in my experience, and I think Judge Lev can probably attest to this if you ask her about it, because she's been using their services more frequently than I have. But in my experience as a criminal defense lawyer, I want to say about 3 years, they are responsive. They monitor people in a way that adheres to the statute such that it can be equivalent to in custody. The difference being when you are monitored more than just where you are at, but also being monitored for abstinence, you will actually wear 2 bracelets that they install. One is called a SCRAM bracelet, or a transdermal alcohol monitoring device, to make sure that while you're in custody doing your time, and they can see where you are going. And even Friendship Diversion actually establishes routes and schedules And if there is even a minute or two violation or a block deviation when you're serving a sentence, they are very responsive. They send an order to the court immediately, and then the court summons that person in to address the issue. So I don't know why more don't use them. All I can tell you is that district court is starting to use them, especially if we have the agreement, if you will, from the state. And one matter I can think of right now is had a gentleman who had 90 days to serve. He was from Skagit County, but he was participating in drug court in Skagit County. And an absence from that would really undo all of the good that court procedure that he had been involved in. And so the parties agreed that friendship diversion was able to monitor him for his 90-day sentence. And I can say that the friendship diversion occasionally checks in and on a longer sentence, and it's been a success.
Thank you.
Thank you, Judge Rich. Judge Freeman?
Yeah, first of all, I want to thank Rupert for the question. He had some really good questions last week too in our work group. So Superior Court will use friendship diversion on occasion. We don't currently have the framework. We don't have a contract with friendship diversion. We don't have the framework for monitoring necessarily yet. We don't have the, district court has district court probation. We do have a single individual working in pretrial services right now, and that has not been incorporated as part of their role. However, like Judge Rands, I got to have quite a bit of experience with friendship during my time as a pro tem judge in all the municipal courts. And frankly, I have not hesitated to use it when the parties are in agreement. I have seen it in Superior Court, both pre-trial on at least one case, maybe two in a different department. And we have used it post-conviction as well. We just don't currently have the framework to utilize it, I think, on a regular basis as of yet. And in those cases, it's been essentially the state that has offered to do the monitoring. We're not putting that on our pretrial services unit as of yet, but that is part of our discussion in our work group.
Can I ask a follow-up question?
Yes.
So Judge Freeman, Friday, the question came up about pretrial services and the number of cases that they had versus sort of their capacity. And you had actually mentioned some issues, I guess, that I'm not familiar with the subject with I guess, absences of commissioners or judges. And it sounded like those who are filling in, and forgive my language here, those who are filling in were less likely to use pretrial services than those who, I guess, are regular commissioners. Is that true, and does that bother you?
Well, I don't know. The question that came up last week was the last 2 weeks, I think our pretrial services reported that they hadn't gotten any referrals. And I did mention that we had 2 commissioners out ill, we still do. And so there was been quite a bit of filling in for the commissioner calendars in the last couple of weeks. So I don't know if that was the cause or not, but that is a possibility. We obviously need to talk about, we've got quite a few new pro tems, which are substitute judicial officers just in the last 6 months or so, and probably have to have more training as far as what they're looking at when they get that risk assessment tool as well.
Rupert, I'd like to thank you for your questions and participation. We really do appreciate the public asking these questions to make sure that everybody's educated on how the system works. I don't want to cut out anybody else in the public, and we are running towards the end of time. I do want to say, as a lot of the municipalities in Whatcom County are using friendship diversion services, we're finding them an incredible asset to the courts. But there are individuals that we can't use them for. There are certain charges that restrict the use of the friendship diversion service tool. So when judges are deciding whether or not they want to use this tool or not, they also have to make sure that it's going to work for that individual. because we don't want it not to be applicable. Thank you, Maya. Is there any other individuals in the public that had their hand raised, Jill?
I don't see any other hands raised. If you want to speak to the committee, please virtually raise your hand now. And no hands are raised.
All right, I appreciate everybody for their participation today. This will adjourn the Legal and Justice Systems Committee.